Hi everyone, good evening. Welcome to the Compliance Shots from LexComply, your global GRC partner. Today, we are honored to have CA Uday Ved with us. CA Uday Ved is a fellow member of ICAI and is a partner with KNAV for Global Tax Practices Group. Udayji is based out of Mumbai, and he had been partner with the Big Fours in his previous years of or decades of experience. He has also authored a book on general anti-tax avoidance rules, GAR, published by Bloomsbury, uh, and has been nominated for a lot of awards in the past. Sir, welcome to Compliance Shots. Uh,
Thank you. Thank you, Gaurav. Thank you for
uh,
having me on the show.
So honor is all us, and today again we are fortunate to have a senior member like you to have an advice on a very again a very pertinent topic in today's world, which is going on that Switzerland has withdrawn most favored nation status of India. So we would like to have some background of that from you and how and what will be the impact on the corporates in India and outside India about it, sir. So want to have your noble words on this, sir. Sir, over to
Okay.
you.
Thank you. Thank you, Gaurav, for having me on the show. As I said, good to talk to you. This is the subject which is quite relevant in the international tax area. See, India has signed double tax avoidance treaties with many countries, almost more than 90 countries in the world, almost who really matter in terms of international trade. That actually gives an access to you know reducing the tax rates on dividends, interest, business income, royalties, fees for technical services. That facilitates more international trade. And as a part of this double tax avoidance treaties, mostly all European Union also have a clause called MFN, or what is called most favored nation clause. What that actually means is that there are different tax rates negotiated for in terms of say dividend, interest, royalties, and fees for technical services. These are the mainly four sources of income. Where the domestic, assuming any foreign company or a non-resident is invested in India and earns dividend income from India, the withholding tax under the Indian tax law is 20%. Whereas under the tax treaty, it can be reduced to 15% or 10% or 5% based on a negotiation. So that gives a little negotiation or a better treatment to that particular country. Now, normally we have seen 15% rate in say India, US, India, UK. However, in Switzerland, as an example, it was 10% when it was signed way back in 1994. Now, there was this uh, MFN clause in India-Switzerland treaty, and mostly India has this clause with a lot of European treaties like Netherlands, Germany, France, Switzerland, etc. What it said is that after the treaty between India and Switzerland came into force, which reduced the tax rate of dividend to say 10%, if India signed a tax treaty with any other nation, mainly European nation, and if the rate was reduced to less than 10, as an example 5%, which was the case of Latvia that India signed later, then this reduced rate should automatically apply to Swiss companies also who have invested in India and earned dividend. This is just to be more competitive or equalize with the rest of the European nation. Now, this question, the debate was there for almost more than 2 decades now. To say this, the reduced rate, India signed treaty with Germany, India signed treaty with France, Netherlands, and here Latvia and a few other countries, to say whether such reduced rate should apply automatically. And a general view at that point of time was that this is for the betterment of trade and an automatic reduction should be available. The Income Tax Authority, the CBDT, actually issued a circular in 2022 to say no, this rate is not automatic. This would have to be a notification issued to perfect that reduced rate. So, and in fact, CBDT issued notification in few treaties in Netherlands, in France, I think, etc. And the reduced rates of dividend, interest, royalties, and fees for technical fees. They're the only four sources of income covered under that. Were automatically reduced, or assuming there was a scope reduced. If it was a more restrictive definition, the scope also applied. So either scope or rate, whichever was lower, would apply to such treaty. There was no such notification in the context of Switzerland. So there were differing views on that. The matter actually went to Supreme Court, the apex court of the country, in Nestle and few other cases. And the Honorable Supreme Court actually held that the notification, such notification from CBDT or Ministry of Finance was necessary. And and that even if notification was done, only those countries will be covered who were the OECD countries when such treaty was signed. The two things Supreme Court held, that the notification was necessary by CBD to give effect to the reduced rate, and second, only those countries which were already had the double tax agreement on that day will apply, not the later countries. And because of that, this matter of almost 2 decades went into litigation, and now with the Supreme Court decision, that's a law of the land, right? It overrides whatever you can say under the domestic law or the interpretation. And so such reduced rate is not applicable to India-Swiss trading. So as an example, the Swiss companies who earn dividend would still be taxable at 10%, and so on and so forth. Now, this being the so-called unilateral action, which is true, Switzerland has reciprocated. So it is no surprise, I would say. It's come as a natural kind of a reaction from the Swiss authorities, Swiss tax authorities rather, to say that the reduced rate of dividend from 10 to 5%. The reverse, let's take a reverse case.
Reverse.
When Indian companies had invested in Switzerland and earned dividend income from them. So they would still be subject to 10% withholding tax and not 5%. Now,
Not
there is
5%.
one interesting observation which has been made in the notification, saying that we will still give the reduced rate up to the date of this notification.
Oh.
So for past cases up to 2024, the reduced rate of 5% is given by the Swiss authorities. Only going forward from January 1, 2025, they said it will be at 10%. Whereas in our case, because the Supreme Court decision came, the interpretation was that from the day one, that reduced rate was not available since there was no notification. So that's one difference, okay, which is interesting. And they said it's not a, they said specifically in the notification, this unilateral action by the Indian authorities in view of the Supreme Court decision, we take this call. So it's more a reciprocation issue than anything else. Now, interestingly, that might create other countries also following similar suit. So to that extent, there will be a larger dividend withholding tax of 10% and the respective rates for royalties, technical service fees, and interest. But of course, you'll get the tax credit back in India. It may actually not have much impact, according to me, because Indian tax rate is generally 25%, right?
Right.
So the reduced rate may not mean much, I would believe, but certainly from a competitiveness perspective, it is an issue.
Okay. So do you see this anyway impacting for some reason ODIs or FDI part of it from the European from Switzerland to India to from India to Switzerland? Any impact you foresee on this part of it?
So theoretically speaking, yes, because that's the whole objective of entering into a tax treaty.
Okay.
And compared to the domestic law, where the rates are what they are, 20% for dividend now, something similar for royalty, interest, and technical fees. So the reduced rate makes that country more competitive.
Okay.
Right. So that impact it should have it. But the fact that Indian company, when they receive this income, would be taxable at certainly more than 5 or 10%. In effect, it may not have much. It's more a perception. Is India changing the law retroactively? So those kind of angle may come in. Although I would believe this is not a retroactive change, because the law has been now gone and Supreme Court has held this. The
It's
interpretation
most
issue which was there.
absolutely
It was
yes.
interpretation issue, but it does create that perception whether there is a tax certainty or otherwise. And I would believe more countries would follow suit something similar. All the European treaties, wherever it is not. Some of the interesting treaties have been notified, so they are already getting that benefit. So they are at a more advantage compared to Swiss. But I don't think there was a 5% rate in any country except I think Mauritius
Okay.
during gold. So in effect, it may not have much impact in my view, except the perception angle.
So I think you're right, sir. I think most important thing, the key takeaway that from the point of view of having ease of doing business in India, it is not an action taken by the government or the
Correct.
authorities, but it is a matter of interpretation which has been taken by the Supreme Court for a 2 decades old case, which has been
Correct.
going on from the interpretation perspective. So from that perspective, I think the message or that point of view has to be made very, very clear. And I'm sure the authorities will be taking up that matter accordingly. And secondly, what you rightly stated that wherein most of the authorities, the things have already been notified already for most of the cases wherein we have tax treaties with the authority with the overseas government. And if you from the Switzerland perspective, also it is something. The good news is it is prospective, not retrospective, which will happen. And the tax
Which
rate
is
are not
really
such.
which is really interesting. Which
Yes,
is really interesting because I think you know there is a lot of transparency and the justice is very quick. See, the other aspect of India is one is ease of doing business and the perception. Second, it takes so much time, years and years, to come to this conclusion, right? So that part, the long journey of you know uh, tax legislature and tax litigation is a larger issue in my view. That
yes.
takes the time. Yeah.
Yeah. Thank you, sir. I think this is something from, from the judicial perspective, this has been a long going discussion that how to make these things simplified. And the government of India has also been launching scheme like Samadhan schemes wherein old tax matters to up to a certain amount can be resolved mutually by within the authorities and the assessees. I think your insight is very helpful, Uday sir, and we look forward to interact with you more on some important topics like this. Thank you for your expert views on this topic, sir. Thank you, sir.
Thank you. Always welcome. Thank you, Gaurav.
Thank you, sir. Thank you, sir. Pleasure is all mine.
Bye.
Bye, sir.
Thank you.
Thank you.